Mr. Gamble.
Good morning, ladies and gentlemen. This will be the last time that I have an opportunity to speak with you. I have as many as 2 hours to speak, and I can assure you it won't be that long, and I'm sure you'll be glad that it will not be. But what I have to say is important, because some of the things that the district attorney said just a moment ago, I'm not going to try to address that particularly, except one thing he said was that this is an easy case. And when I first came before you, I told you this was a case in which the state had a case that was filled with suspicion but empty on evidence. And then this is exactly what I mean. Would the state consider this an easy case that did not require any investigation, did not require much to be done because they were so sure of who they thought it was that was responsible, they failed miserably in every phase of the investigation otherwise? And if you look at the evidence, the question that was put on the screen about whether or not any of this has to do with the death of the child, this is not a case about whether or not the child died. We all know that. If that is what the state needs to prove, they have done that. And we concede that. That is not what this case is about. This case is about the state of Georgia accusing this young lady of a very serious crime of murder. And when the state makes a claim like that against someone, it is their sworn duty to prove it. And not just a little bit, but prove it beyond a reasonable doubt. That meaning that if there is any other reasonable explanation for what could have happened, any at all in your mind, you cannot come back with a guilty verdict. Now let's look at what we have in this case. And I'm going to go through several things. You got to imagine I'm having to unwind quite a bit of evidence that's come through these last 4 or 5 days. But I'm going to try to take you through, not piece by piece who testified, but about certain things that matter. And the first one is, and a very important one is, that Agent Gibson came and testified. You remember, he is the person who said he is a crime scene specialist. He also has special training in crime scene preservation. He said he was told to go to a particular location where they believed the crime scene occurred. That would be the dorm room at the Oaks of Trinity Poague, where also Mr. Williams had been staying and the child. Now we know when he went there that really quickly after arrival at the hospital, an officer was posted at the door and it was taped off and someone stayed there, and so no one came back to that room after Mr. Williams and Miss Poague left that room. We know it, one, because it was roped off and had an officer there, but also they got video. So we know if someone had come through in that dorm and tried to mess with anything from the time they left until the investigator got there, that's not possible. Investigator says that's right. So we don't have a question about has there been a cleanup in this room? Has there been some tampering in this room? Nothing has happened in this room except the people left, and they left it in whatever condition it was in at the time they left in a hurry to go to the hospital. And what did he tell you about his investigation? He said he took photographs of everything that he saw in each room because they like to show the setup of each room to begin with and let you know everything that's there. And then his secondary purpose and most important purpose was to gather any evidence that he felt was important to the case that could be used in this case to prosecute the case, whether it be against Ms. Poague, whether it be against Mr. Williams, whether it be against some third party, who knows, but to gather that evidence. And I asked him, at the conclusion of questioning him, isn't it true that you did not obtain a single piece of evidence that was any use to you in this case? And he said, yes, that is true. Not one thing. I asked him, did you find any blood in that dorm room anywhere in that location, in that vicinity? His answer was no. Did you collect any type of human fluid that you thought would have been beneficial to tell you something? He said, no. I said, did you find any type of weapon in that room that might have been used, any kind of instrument that could have been used to cause blunt force trauma? Did you find a bat? Did you find a paddle? Did you find a statue that's sitting in the room that might could be used? And his answer was, no. I found nothing that I think could be used as a weapon. I asked him, did you find any place in that room or those couple of rooms where it looked like someone could have hit, a an arm of a chair sitting out, or a high countertop that might have a sharp edge, anything that looked like it could have been a child pounded into. Did you find anything that would have drawn your attention where you got evidence? He said, no. So what about the walls? Did you look at the walls to see? You would look at that. Yes, I would. Did you see anything? His answer is no. So we know that the state claims they have a crime scene, but a crime scene in which they have obtained zero evidence from. I'm not talking about a little evidence, zero, unless you believe Agent Ford, I think, said they did get a receipt from Walmart that proved they went to Walmart to buy the drinks. I'll give them that. That's it. Nothing of evidentiary value from a supposed crime scene. Now remember, they said this is a violent, massive force injury. Yet there's no evidence within that room of anything that occurred like that. And I remember I asked the agent, I said, well, have you ever heard of luminol? A lot of people I know have heard of luminol. Luminol is used to spray it across a room in case you don't see blood evidence. But just because you don't see it doesn't mean it's been cleaned up or there's only a small spot and you can't see it with the naked eye. Spray it with luminol, turn the lights down, turn on a certain light, and if there's any particular speck of blood, it'll light up. And I asked, did you do that? And he said, no, he didn't do that. He didn't offer an explanation why. He just didn't do that. It is inconceivable that someone individually, intentionally, did harm to this child in that way, and it didn't leave some type of forensic evidence in that room. And remember, you also told the child supposedly was throwing up on the way out of the room, and there was no throw up coming out of the room into the hallway. No evidence. The state is required to provide evidence. A defendant comes into a courtroom under the law cloaked in innocence, and it does not be removed from the defendant from the time they enter until they leave, unless some actual evidence comes in that can disprove that innocence beyond a reasonable doubt. But their crime technician, the one that's charged with collecting evidence, has collected nothing. So we don't know if that's a crime scene or not. We didn't get any evidence from it if it is. And we also know when I interviewed and questioned most of the arresting officers and the GBI agents, anyone that was involved in this case, the autopsy people, all of them, we do know that the child suffered from blunt force trauma. We know that. But not a single person that I asked, number one, I asked each one, can you say, based upon what you saw, who did that? And the response for each of those persons is, no, I can't. I can't tell you from what I'm looking at, from what I observed and what evidence I had in front of me. I could not tell you. I could not say, yeah, I can tell you so-and-so did it. I can't tell you that I took ballistics from a gun and I can show it matches John Brown's gun. No. I can't tell you I found a weapon that was owned by somebody and now it's been used. And more importantly, I can't look at the body and tell you of a single mark that shows there's anything been done to it other than it has blunt force trauma, but not in a sense of you can see a paddle mark or a baseball mark or something that says someone did this to this child individually. They have none of that. So they don't know who, but they also don't know how. I asked the autopsy people. I asked Agent Ford. I asked every one of them. Do you know how? What happened? Well, they've got some theories. Maybe this, maybe that. I don't know. We just know the child had significant injury. So now we don't know where the crime scene is. We don't know necessarily who did it. And we don't know how they did it. We don't have any type of weapon. We don't have any type of instrument that supposedly caused it. And you're left with some speculation of, well, could it have been just the hands of someone, just the person themselves? Could they have done that themselves? And somehow grab him, somehow punch him? Trinity Poague had done that. She had grabbed a child and done that with her hands. Well, you would think if that's a possibility that the GBI would have looked at her hands, photographed her hands, would have looked to see if there was any signs that she used her hands. Because remember again, This is a violent force, blunt force trauma. She used her hands to cause that, and you talk to her within a few hours of it, and you look at those hands, it's going to show. Whether they're going to show redness from blows, whether they're going to show scratching, whatever it may be. And it took quite a bit of pressure, of course, according to Dr. Clark and some of the others that testified. And we also know Mr. Williams was around the child. Who's more able to use great force to cause injury? Who knows who caused injury? But if there is injury, we do know from Mr. Williams, nobody looked at his hands either. They didn't do anything to check that. And they didn't do that because they weren't going to check on Mr. Williams anyway. Because they were already down the rabbit trail they went down to begin with. That Trinity Poague is guilty and we don't need to look at any other evidence. Now you know that because I talked to Agent Ford, and I asked her about what their investigation do. We know that she talked to everybody that she knew in that dorm or had agents with her do so, interview them all. Try to find out what they know. She got a phone. She got a phone of Mr. Williams. She did a few other things. She talked to different people. Well, then when I asked her about what efforts she made to try to find out anything about Mr. Williams or his sister, Ashante Burr, what did they tell me? And the reason I asked that before I go any further, remember I asked that agent, I said, when you have child abuse cases, isn't it true that sometimes or often you find that a child has had injuries before the situation that leads to their death? They kind of show there'd been abuse in the past, but now it's occurred. And she said, well, not all the time. And I said, but sometime, right? And she said, yes. And I said, isn't it important to then look, to try to see, to try to find out if that's the case? Now, she discounted and said no. Why did she say no? Because we already had a dead child here. I know it was in that dorm room. I don't need to look anywhere else. That's what she told me. I don't need to look anywhere else because I know where it happened. That's it. I don't need to look. I said, did you go to the house where the child lived and at least look at the house? No. I said, you wouldn't even know how to get there. Right now, if I wanted you to take me to where the child lived, and the answer is no, she wouldn't. Not even looking to see what type of condition was she living in. I don't know. No one knows. They didn't investigate it. Did they talk to any neighbors to see anything about the relationships going on? No. Did they talk to anybody that he worked with? No. Did they go to his workplace? No. Did they make any effort to find out? No. Because they'd already gone down that trail. And they decided at that point that this is the story we'll tell, and you'll see, and I'm going to talk about this in a little bit, about the testimony being shaped to make sure it fits over here. And struggle and fight no matter what to keep it there. Because that's what they decided early on, and they don't want to break away from that. But now you have a case, you got no evidence. None whatsoever about how the blunt trauma was occurring. You don't know for sure where it occurred. You don't know who did it. But they say it's an easy case. They say now we just got to look at it and we should be fine. But you know, maybe the most important witness that came in this courtroom was the one that's not tied up and connected with everyone else, and that's Dr. Busman. You know, the rest of these folks, they got some allegiance one way or another. GBI can say what they want to. Dr. Clark's been working for the GBI forever, and yeah, he's going to testify for the GBI, and you can bet your bottom dollar he's going to support whatever side he came in the court to testify about. He's not going to break off of that. And you got these law enforcement agents, they've already gone down the rabbit trail. They decided what they know. They're not going to break off. But Dr. Busman didn't ask to be in this case, didn't want to be in the case. He had one duty and one thing he had to do. And that was he was an ER doctor, and he had to try to give some type of treatment for this child and see if he could save it. That was it. And then he got called to come testify. And he had to do that. I'm sure he didn't want to. As you could probably see at least somewhat, he wasn't that comfortable in testifying, but he testified. So you can bet he was trying to be truthful about what happened. He told you some things that were extremely important. And one of the things that, as important as anything, I believe it's exhibit number, let me make sure I got the right exhibit here. Exhibit 26 is the medical record from the treatment that he gave the child when he came to the emergency room and all that happened. And that record's already been introduced. It's an authentic record. You're going to get it back with you. You can look at all of it. And it's got some pretty important stuff that's contained in it. The most important stuff it's got that's contained in it, if you look at that document, and I'm going to ask you that you do when you get the chance at the end of this trial, you're going to see that there are numbered pages. There's 2 sections of numbered pages. You first look in, and there's just a bunch of preliminary stuff with no numbers on it, maybe 20 pages worth, 15 or 20. Then you'll come up with pages 1 through 39. Well, in that section of 1 through 29 on page 23, you'll need to look at. And then you'll see a second section of 1 through 28, and on that section you need to look at page 20 and 21 of those. Now, why do you need to look at those? Because those medical records on 3 separate occasions say within the record that the father presents bedside and states the child fell around 5 minutes prior to arrival. Why is that important? First of all, we know from Dr. Busman that the only person bedside was the father. The girlfriend, Trinity Poague, was not there yet. So the only person, it's not a mix-up that they said he told. We know that because it's in this record. Now, what was interesting about that, did you see how the state struggled so hard when they got back up to pull that out of the record? To say, well, didn't that get entered a few hours later? I mean, that didn't happen right away. Trying to insinuate that maybe some mistake was made. Maybe that's not really what got said. On, and Busman, you can see he was almost confused. Why is that happening? But I'll tell you why that's happening. Because they didn't like what Busman had to say, and they didn't like what he had to say because it's a lot more than just the father coming in with a story that we know is not true. We know that the child didn't fall 5 minutes prior, or don't think he did. Or if he did, maybe the father knew it and we didn't know it. But they try to then claim that maybe Miss Poague had told him that, and that's why he told the doctor that. Remember when I got Agent Ford up and started asking her about the interview she did with Mr. Williams? But before I put her up, I asked Mr. Williams, did you tell the agent when she first interviewed you what you believe happened to cause the injury? He said, first interview, yes, I did. Second interview, I said, did you tell her? Yes, I did. And I put the agent up and asked her, can you tell me, here's your summary. If you look at it, do you have it from the first interview that first occurred when you got there with Mr. Williams? Yes, I do have it. It's 10 or 12 pages long. Okay. Can you turn to a certain page there and tell me, if you're looking at that, tell me anywhere do you see where Mr. Williams says what he thinks caused this injury? She said it's not there. In fact, what she read from that report was him saying that he came back to the room and asked Miss Poague what happened, and she said, I do not know. And then it said that nothing else in the report. Now first, the agent wants to avoid that too. She doesn't like that. She's protecting her story now, trying to make sure that we got the blame for Trinity. That doesn't fit the pattern. So she said, well, it may be in the report somewhere else. And what I told her, we got time. Read your report. Go through it. When you get through, let me know if you find it. Well, we sat here a few minutes, 5 or 10, but guess what? She finally said, I've looked. And I said, did you find it? She said, no. Well, then here came the real squirm. Let's say maybe I just didn't put it in the report. He may have told me I just didn't put it in the report. That's interesting. You've got a trained GBI agent that is taught that anything of importance will be put in a summary report to make certain that you're preserving that. We know that. We've heard testimony about that to some degree. But yet, someone tells them because they believe of what could have led to the injuries to the child, and they don't put it in the report. But maybe they got told and forgot it. And she says that on the first one. Well, the second report, I asked her the same litany of questions, said, what did he tell you there? And he said in that report, absolutely, he did not know what happened. He didn't say, but my girlfriend told me something. He didn't say that I know something. He just said it didn't happen. So we know when he went to that hospital, no one had told him anything about a fall. That came from his idea. That came from his mouth. Now, if he got interviewed by the GBI and he knew it, you can bet your bottom dollar in that only an hour or two after all this occurred, he would have said, yeah, the girlfriend said this. So we know that came from him. But we also know he didn't just tell the hospital that. Lieutenant Allen told us. He came up when it was going on, remember? He saw him come into the emergency room. He saw him standing in the doorway watching while they were doing the workup. He pulled him back and talked to him and asked him what happened. And guess what he said he told him? That my son just fell face down a few minutes ago. Again, twice he's told that version. Twice he's told a different version to the GBI. And you know, if you really get down to it, looking at some of the questions for Mr. Williams, let's talk a little further. Remember when he got on the stand, he told those two things that it seems pretty apparent that maybe they weren't exactly on the up and up, what he was saying. Well, let's get to the third one. I asked him about being interviewed the third time. And the third time was important to me, maybe more than some other people, but I wanted to know, at the time that he was interviewed, did the GBI agent allow his sister to come in and be interviewed with him in concert? And he said, well, yes, she came in, but when she came in, I left. I said, so you're saying if they asked her any questions, you left. And he first said he wasn't really asking questions, just looked at cell phone stuff. But then he said, no, if she asked anything, I left the room. That's what he said. That's what he told us, right down that witness stand. What he said happened. And that's important because, remember, I was asking the agent earlier. I asked her when we were talking about Mr. Williams and Trinity Poague, I said, when they were at the hospital, did you just interview them together? I mean, they were already there together. She said, no. And I said, why not? She said, of course not. I wouldn't do that. Why? She said, well, you know, it wouldn't make any sense. You would divide them up. And I said, that's because it's protocol from the GBI. And she said, well, I wouldn't say it was necessarily protocol. I said, well, you think it's from training? And she said, well, I think training might have tell you to do that, but it's common sense that you would never put two people in together to interview them. I said, you wouldn't do that. She said, no, I wouldn't do that. Well, now Mr. Williams talks about that. And I brought the agent up on the witness stand. And I asked her about it. And she got amnesia. She said at one point, it's been 2 years, I'm not sure. Is that the standard we're using here for this case today? That it's been 2 years, so I'm not sure. So everyone that's come in from the police department, well, it's been 2 years. I mean, I'm not sure we can depend on anything if that's the case. It's been 2 years. I'm not sure. Are we to believe that agent hadn't reviewed her case file before she got here today? Or yesterday when she testified, or starting on Monday? She just came in after 2 years and just winged it? You can bet your bottom dollar she'd already looked at everything. She didn't want to talk about that interview. And then, when we refreshed her memory, what did the interview show? Almost 20 minutes, interview by themselves, 40 minutes with him and his sister together. Now, why would it matter him and his sister? Well, it matters because him and his sister are who is keeping the child. We know from the evidence that the sister actually did more caretaking from the child than he did. She fought me about that some too. Well, I couldn't say that. You know, he might have been some. Well, first of all, she can't say because he didn't do any investigation to determine. But we do know a few things. We know that he came to the college at least twice a week, every week, and he came every weekend. And most of the time without his child. 4 days out of 7, he is not at home. He does not have his child. He has left the child with his sister. She is the caregiver of his child. Now, if she is a caregiver of the child, and there is some suspicion of any alleged abuse, it would make a lot of sense to try to separate people and talk about that some. Not put them together so they can be interviewed and get their stories together. But that is a sign of what was going on here. That we're not worried about them as being any suspect. We've already decided this case. We decided this case when January the 14th came, by 5 o'clock in the afternoon, it was over. It may have been a couple more days before the arrest occurred, but the investigation had shut down, and nothing else was going to happen. You were just going to have to live with it, and too bad. Why? Because we got suspicion. We have suspicion. Well, it's a scary world out there if your government can all of a sudden just decide I'm a little suspicious and I can arrest you. It's a scary world. But you have that going on, but think about that sloppy investigation a little bit more. It's not just that problem. Remember when I asked the crime scene specialist about the dirty diaper? Now, he already knew that was coming up because we had filed a motion to ask to test the dirty diaper. We wanted to see if it had blood in it. And I've already asked Dr. Busman about it, and he said normally he wasn't sure that you'd have blood in your system from abuse, but I got to ask him, but you could have some trauma at times that causes you to have blood in your bowel system. Can you not? And he said, yeah, you could. I don't think the injury that's caused his death would have caused that, but it could be from trauma. It doesn't take a genius to figure if somebody punches you hard right in this area that you might end up bleeding from that area through your system. It doesn't take a genius to figure when you hear about boxers when they've been finished a hard 12-round fight that sometimes they bleed out the rear end from it for days on end. It doesn't take a genius to know that you got trauma in here, that you will have blood coming through, and it takes time. I asked Dr. Busman, how long? And he said, well, you can't really say because obviously people's systems work different. A few hours to maybe a day or more. What does that mean? Well, it means there was blood in that diaper. We know a few things. It did not come off of that child on the day the child was taken to the hospital. The child had on a diaper different that they took off of that child at the hospital. There's pictures of that. So it was previous to the child going into the particular situation that led to the hospital. And probably many hours passed or even a day passed back. If it's many hours back, whatever had happened to cause that cannot have happened at the hands of Trinity Poague. Because we have a very short window of time you can claim Trinity Poague did anything, which would be from 10 o'clock or 10:15 on Saturday night until 12 o'clock on Sunday. About 14 hours. That's the only time period she was around the child in that within a week or so. Well, why is that important? I mean, you say, well, that's still not what caused the blunt force trauma. No, it's not. But if you find that to be some abuse that caused that, it certainly would make you start looking a little further as to who might have done it. But if you choose not to investigate it, and worse than that, throw it away. So that this girl right here has no chance to defend it because the test that could have been run cannot be run because they threw it away when they knew it was a test they could run, and he got on the stand and tried to make like he didn't know that. I don't know anything about a fecal test. I've never heard of being able to test it to get for blood. I asked if you ever heard of the test, and he says, oh, no, I've never heard of it. And then he starts realizing, boy, that's going to be trouble, so what does he say? Well, I do keep a test for myself that I can test for blood. If I'd have seen blood, I'd have tested it. He hadn't said anything about that the whole time I've been asking. All of a sudden he pops that one up, but said I didn't see blood in that diaper. Now here's where Dr. Busman really comes in. It's really important. Why he's one of the most important witnesses. Dr. Busman had no idea about the diaper. You could tell that when I asked him. I told him before I asked, you're going to find these questions a little bit weird or something to that effect. Y'all finna go on a path that you may not understand. And I asked him about those diapers. And I asked him if he had experience with blood and fecal matter. And he said, yeah. Oh, yeah. I said, you probably tested it, hadn't you? Yes. Is there a test? Oh, yes. So a hemocoat test. Easy. Easy. It's done. I said, is it done quite frequently? He said, well, I don't know about frequently. I said, but yeah, you've done it more than a few times. And he said, yes. I said, if you see what you believe may be blood or suspect it, do you run them? Yeah. He said, there's two ways I do it. Sometimes you can just see blood and you know it's blood. Other times you look and you say, well, maybe I better test it. And I said, so you can observe it, yes. And then, if you will, put up that diaper number 2. I showed him this photograph right here that you're going to be able to take back with you to the jury room. I showed him this photograph that I'm talking about, that he had never seen, had no idea about it. And my first question was, Dr. Busman, looking at that photograph, does there appear to be blood in that diaper? And he said, yes. I'd say probably so. Now, yes, that sent the state back scrambling again, where they tried to rehabilitate that answer and say, but yeah, it could have been something else. And he finally said, well, yeah, maybe like if there was dye in some food, it might have caused the discoloration. But in his opinion, just eyeballing it, yes, that diaper seems to indicate, you see right there on that screen, blood within it. He said, your crime scene technician didn't think that. Now, you decide which one you want to believe. That's your job. The credibility issue of which one should be believed. Dr. Busman, who's done tests many, many times to test for blood, or this agent that decided to tell you all of a sudden that that wasn't worthwhile. And it's interesting to note that diaper was not unfolded when he got it out of the trash. It was in a ball. That was the first exhibit 1. You'll see those diapers together. He took a picture of that, and then he unfolded them to take pictures. So you know that he knew that that might be evidence. There's no reason to open them up and take a picture. And yet, after he got them, and once he saw what it looked like, he just chunked it back in the trash and left us with no way to test it. He left us with no way to test it. So he doesn't care about what Trinity Poague has to say. He doesn't care about that at all because that doesn't fit his case. That wouldn't help him prove his case. That would hurt his case. So he chunked it away. Chunked it away. It's inconceivable that that was done. The crime technician tried to make like 1. He doesn't believe. You can take it down now. He does not believe that it is blood in that diaper, or number 2, that it should be tested. Because if it was tested, it would show, obviously, there was some issue going on with the child. Now, the other things could be going on. The child could have colon cancer, which would be almost unheard of for a 1.5-year-old child. Could have some type of ulcer, again, be extremely unusual for a child that age. If that child that age is bleeding, other than right around the very bottom of the bottom where it might have had some kind of irritation, it came from trauma. If it came from trauma, and we came in the courtroom and show you that, well, then you really got to wonder, why are we not looking? Why are we not looking a little bit further? Now let's talk back a little bit about the statements that there's no one that's been alone with the child but Trinity Poague. No, there's 2 people who've been alone beyond Trinity Poague with the child. Mr. Williams was alone with the child for a period of time. I'll talk about that in a second. And more importantly, the child itself was alone for a long period of time as well. Now, you may remember the testimony of Mr. Williams when I had him on the stand on the day of, the morning when this all erupted. I was going through a litany to try to determine what was he doing and what happened. He said they got up in the morning. He didn't know the exact time. Nobody really gave me a time, but we do know he laid on the bed, and he said he put the child on his chest, and he also said at that time he had ordered the pizza that you know that he went to get. We've got proof of that. Well, you can assume then from that, we don't have concrete evidence of what it is, that he must have ordered the food at some time getting toward the time you would normally eat. In other words, it's unlikely it was 8 o'clock in the morning he ordered the pizza. But regardless, he orders the pizza, and once he orders the pizza, they did not eat the pizza right now and go get the pizza right away. He told us that he got up after being there with the child for a little bit, after having already ordered the pizza, and I'm assuming he's giving enough time for the pizza to be made, so he didn't want to just leave right away. He and Trinity Poague got up, took a shower together. And that's important in itself, together, because we know from the text messages you're going to see that are going to be introduced into evidence. One stream was to Miss Poague's roommate, where she's talking about, in one sense, on the Saturday night that she had told Mr. Williams, I'm through. He wanted him to go home that night, but he wouldn't. And she said, but I'm going to go ahead and let him spend the night with J.D., but she wants him to leave. It's over. I'll be the first to tell you, we've already heard a bunch of evidence that it was a on again, off again, I'm breaking up, I'm getting back together thing. And so I don't put a lot of stock to I'm broken up and necessarily saying that it was over. But it could have been what was going on. I do know that Mr. Williams had been drinking the night before. He says only a glass or 2 after he got there with the child. Questionable whether that's true. We know that we have a bottle of liquor that only has about that much in it that he left in the dorm room, and we know Trinity Poague didn't drink it because he admitted she doesn't drink rum and wouldn't have, and it was his rum. But he tried to say that got drunk at some other time. We don't know how much he did have to drink, but that night we know he went to sleep before everybody else. Saturday night, a young man in bed by 10 o'clock already, and sound enough out that when the crying of a child that woke people up in the dorm at 1 o'clock or thereabout, he didn't wake up either time. So it's reasonable to believe he woke up hungover, not happy because his girlfriend is wanting to break up, and he might not have been in the best mood. Or it's also reasonable to assume that maybe the romantic breakup is being a makeup now because they're going to the shower. And if they go to the shower together, and they're young people, and they're making up, the chances are of them being in the shower for only 5 or 10 minutes is pretty slim. I mean, when you go in the shower with your mate, it tends to make the shower a little longer for young folks, sometimes even for old folks like me. But I can tell you, when they go in that shower, they didn't stay in there just 5 minutes or 10 minutes. They are showering together and most likely doing other things. I'm not judging that. It matters to me. But what does matter about that is a 1.5-year-old child is sitting in that little pink chair that y'all saw a picture of earlier and will get a chance to see when you go back to the jury room. And that little chair that sits there, there's not a danger to the child as far as I can tell of something happening in the chair. 1.5-year-old that by testimony by Ms. Permont back in October, she was watching the child learning how to walk. He's a toddler, so now he's got a few more months under his belt of walking. I don't know what in the world that child may have done while they're in the shower. I do know this. They were probably in the shower for more than 5 or 10 minutes, maybe 20 or 30 minutes, a pretty long time in the shower. They're in there. The child, I've got children, you got kids, my kids when they were growing up, my 1.5-year-old boy, if you left him for a minute by himself without looking, he might be on top of a chandelier somewhere. He would climb and go and do all kinds of things. And who knows? Who knows what that child was doing right now? Who knows whether that child himself on that morning climbed up on something and fell back off of it? Who knows? But what we do know is that when the shower ended, Mr. Williams was the first one out of the shower. He testified to that right here and said he got out of the shower first and Trinity Poague got out next. Now, you can say, now, well, so what? He got out and immediately she got out. But he said something else. He said, I went and I was staying there with J.D. and I was waiting on her to get out of the shower before I left. Well, that tells you two things. Waiting is a term you would use if she's taking a little time. Not I'm waiting as she's following me out of the shower. But secondly, he told us as soon as she got out of the shower, he waved to the child and immediately left, so we know he was fully dressed. So he got out of the shower and got fully dressed before she came out of the shower. So there is a time period where he was the only one around this child. And there is a time period when the child was alone and no one was there. Now, I can't tell you that something happened when that child was by itself. I can't tell you there was something happened when Mr. Williams was there with the child. But I tell you one thing else. I can't tell you something didn't happen either. Because all we know is that was the situation. And so to say that there was no other opportunity for anyone, and the evidence they brought into court was if something had happened, it would take anywhere from seconds to a few minutes for it to show signs. Trinity Poague gets out of the shower, the child is in the chair, he scoots out, she's getting dressed, she's cleaning up around the house, doing the things you do. It might take a few minutes. You can see over in the chair a little ways, but not think a whole lot about it. Finally, if you go over there in 10 minutes or 15 and go, uh-oh, what's going on here? It's something that happened to the child, whether accidental or maybe worse. But you can't discount that. You can't say that's not a reasonable proposition of what could have happened, because it could have happened that way. And we don't know for sure. And we don't know because there's not been an investigation. There's not been anybody that's tried to push on those issues. They just said, we're just going to accept it for what it is. When we see you got a child that's not alive, and we're going to blame it on Trinity Poague. That's what we're going to do. That's what they did. And you'll see that Trinity, and I'll talk about this a little bit later, but Trinity told people at first when this at first occurred, she had said that the child had fell off the bed. She had actually mentioned that the night before, talking to Mr. Permont.
Objection.
Let me not told, but said through text message.
Facts, not in...
Through text message, I'll take it back. Through the text message. She didn't tell in the sense of talking. But you'll see on the text message from Ms. Permont where she said that the child had fell out of the bed the night before. And you'll see that she said that then. And so then you have not only her statement that happened, but I brought 2 witnesses in to talk about they heard a baby crying sometime between midnight and 1 o'clock or so, loud enough to wake them up. Now, these weren't even particularly favorable witnesses to me. They had some things to say that weren't all that favorable for Trinity Poague, but they were important witnesses because they established when she said something happened that night that fell out of bed. Well, you got 2 witnesses that said, well, I'm right across the dorm, one straight across and one to the caddy corner, and I heard the baby crying enough to wake me up. Now, they both said the baby would cry a lot of different times for various reasons, but this was enough to get their attention. So we also know that happened. Now, she did say, when some of the records will show, there was a claim, if you remember, Dr. Wright, or Reverend Wright, I should say, said that she claimed that the child was in distress and fell out of the chair. Talking about that little pink chair. Well, if you look at the pink chair, you'll be able to quickly see she fell out of the pink chair and nothing happened. I would suggest to you, and I believe that I asked him about it as well, that what she meant by that is when she noticed a child in distress, the child was slumping over, and it just sort of slumped out of the chair. That was not the cause of the injury. She was not presenting that to say it was caused by the child falling out of the chair. She was telling them, what do you know? Well, I came up, the child's in distress, and it fell out of the chair. She wasn't insinuating. There were 2 different things here. 2 different things entirely. You know, I had lots of questions I was asking about possibilities of falling out of a bed, and I know that some of the experts try to discount that to some extent and want to say, well, we're not talking about it. Time may not be right. Or, I don't think that injury could occur. 40-inch bed is pretty high. 40 inches as high as my hips. You're talking about a small child that's 31 inches tall, falling onto a hard concrete floor. That child lands flat, bam, the back of its head, and have some significant injuries. But I asked Dr. Clark about it, and he was kind of waving around, but then I asked him, remember, about particular scientific journals and treatises. And he didn't know I was going to ask him about it. I didn't know that he would know what I was talking about, but I asked him if he was familiar with Mary Case, Dr. Mary Case. She's a forensic scientist out of St. Louis County's forensic department. I said, is she well known? Yes. Do you know her? Yes. And I said, how do you know her or whatever? And he said, oh, I just went to a seminar, a week-long seminar with her. I've been to 2. You could tell. He valued her opinion. And I brought that up because I wanted to point out a fact that was contained within that particular literature. And there was a particular page I turned him to. And I'm going to read you about that page one more time because I think it's critically important. The paper was talking about accidents in which children had fallen from not particularly large heights, and it was severe enough that it killed them. And admittedly said it was rare. It didn't happen all the time, but from time to time, a fall would occur that would appear that wouldn't be enough to cause significant harm, but did. And the first case study said that a 4-month-old male child was taken to a children's hospital. They did a CT scan, and it came back normal. He would not eat or sleep well. He survived for 2 days. They would then decide to take him to see his pediatrician, and he died on the way there. They said he fell out of an adult bed and struck the edge of the bedside table. So an adult bed, unless it's something really unusual, would not be even 40 inches tall. A second one said a child that was 21 months old, male. He cried after he had fallen. He was able to be comforted. He vomited, but then put back to bed after he was through vomiting. They found him dead in the bed the next morning. He had fallen out of his own bed. A third one was a 7-year-old female who fell off of a 36-inch tall tree stump, and she hit the back of her head. She complained of headache and vomited several times. Over the next 12 hours, she's found dead the next morning. And then finally, a 10-year-old boy who had fallen off his bicycle, and he was found on the ground. He went to the emergency room. CT showed a fracture of the right temporal. Then it cuts off as to what happened. But he died. Now, these all involve subdural hemorrhages. Now, expert, Dr. Clark, wanted to try to walk away from that some by saying, well, wait a minute, those deaths weren't caused by a fracture back here. They were fractures somewhere else in the skull, so that just sort of didn't count. Well, one of them did involve falling on the back of your head, but regardless of whether they were the exact same fracture, it's pretty good proof that at time to time, a fall from not too high can cause significant injury. And if indeed that fall from the bed caused that, and sometime it can't be discovered right away, and you looked at it, you see these examples, no one thought these children were in great danger. Two of them went to the doctor, hospital, and were given the clearance to go home, and they died. This young lady here, Trinity Poague, she's not a doctor. There was no real visible signs, even according to the doctor, to the officers that first looked at the child. There was not in a real heavy area of what might be considered harm, where you would look at the child just visually and think something serious was wrong. In fact, even the autopsy doctor said, and the doctor at the scene of the ER said, you had to feel the back of the head to realize that it suffered any injury. If that child got injury out of the bed around midnight or later, it may have taken a few hours before it all of a sudden erupted and showed itself. Trinity Poague had no reason to think that was any serious injury. She would have no reason to. And she certainly would not have been the person that caused it. And if that's a possibility, and it certainly is a possibility, there's enough evidence to show that that most likely did happen when a child falling out of the bed, that's reasonable doubt as well. You cannot say that Trinity Poague was the cause of it. And I know, ladies and gentlemen, that you've heard some other things that you may have questions about Trinity Poague's posting of certain text messages that are in evidence already. She was in an immature relationship at 18 years old with a 23-year-old man, and she made comments from time to time as they went back and forth with their up and down relationship that could have been said better. And she did say at times she did not like the child and those type things. But never once has anyone said that they saw her in any way trying to in any way harm that child, including the father never said that. He never claimed that there was anything abusive going on. These were a matter of speech. It's much like if my wife were to go out shopping and come home and I thought she was buying a $100 coat and it was $1,000, I might call one of my friends and say, I could strangle my wife. She just bought a coat for $1,000. Do I mean I'm going to strangle my wife? Of course not. Poor language perhaps, but just simply talking, in this case, mostly to Miss Permont, who is her roommate, who is a person that she is very close with, who that she discusses her relationship. In fact, you will see in this thread of information on the text messages, you will see where in parts of this, Miss Permont sort of agrees with her on stuff. She's talking about having trouble in State's Exhibit number 39, and she asked, is he sleeping with J.D. in your bed? And Trinity replies, probably. And she says, TRIN, that's so messed up. Make him get on the air mattress with his child. That's not your kid, and y'all aren't together. I know I told him after the night he better not contact me. Is Trinity's reply. This is a conversation between Permont and Trinity. So we know a few things from just that little thread. First of all, Miss Permont's saying to her, you need to quit letting him just give the child to you while he goes and sleeps and does whatever he wants to and won't tend to the child. It's his child. Tell him to come be responsible for getting him into bedtime and doing what needs to be done. So she knows that that's been an issue. And then secondly, officer a place to sleep, and she says in return, though, after the night, better not contact me, let you know it's on that downswing again. That's what I was talking about just a moment ago. And then there are conversations after that. But this is not proof at all of any type activity by Trinity Poague toward that child. You know, you don't have any evidence that Trinity Poague made any type of confession, which of course she did not. You don't have any evidence that she talked to some people after this event and has told them incriminating evidence somehow or another and they brought it into court. Again, you have no evidence that says she committed this crime. You have the suspicion that she committed this crime that is given to you by the district attorney and then by the state of Georgia without evidence to support it. Now, you also heard that she searched some items after she was at the hospital about skull fractures on her phone. And I want to be very clear so there's not any confusion about this. This is not a search that was done before the child had been injured. This is not a search that was done during the injury of the child. This is a search that was done after she was at the hospital and after Dr. Busman met with her and Mr. Williams and told them that the child had a severe skull fracture and was likely not to survive. Now, at that point, you can look at this, and I'm going to tell you where to look on this as well, because I think it is very important that you see this as well. On those same documents, the one that's 1 through 39, the medical records, if you look at page 38 of 39, it has a colloquy that shows at 1:15 that afternoon, he spoke to the family to update the condition. That is when they meet and say, this is really serious. Trinity Poague, an hour or more later, and then 3 or 4 hours later, did search terms about skull fracture. And what does that mean? And how can a child have a skull fracture? That's very logical to assume you would do that. If someone told me my child had a skull fracture and I had seen nothing happen to cause anything to injure to the head, I would want to know, how can that be possible? And I might even say to myself, well, I know he fell off the bed, not that high of the bed, but is it possible that he fell off the bed and it caused it? And I would search. And that is what happened here. This is not, again, the way the prosecution wishes to portray it. They want to try to make it some nefarious, evil thing that was done. She did the thing that anybody would do. Check and try to find out what in the world does all this mean. Trinity Poague was 18 years old. She was living alone for the first time in her life at Georgia Southwestern College, and she'd been there one semester when all this happened. She came to the hospital after a traumatic event happened that she had no idea what was occurring on a child that was in distress, on things that she had nothing to do with, and did not know what was occurring. And then found herself within an hour or two being interrogated by GBI agents, by police officers, all that you can imagine, and her trying to figure out what in the world is going on. Now, ladies and gentlemen, you've been sworn in to follow the law in this case, to make a decision on whether or not the state has a right to say that she committed a crime, a serious crime. And your duty is to hold the state to their duty, which is they must prove that case, each and every element, beyond a reasonable doubt. If any doubt exists whatsoever that is reasonable, you cannot convict. You cannot discount the possibility that Mr. Williams could have been responsible. You cannot discount the possibility that an accident happened to the child while they were showering. You cannot discount the possibility that the fall from a 40-inch bed caused injuries to this child. All of those are reasonable doubt. You cannot come back with a verdict otherwise. You know, this place that I'm in today, I've been practicing law now for longer than I sometimes want to admit. And I've had many a trial, but it never changes in one respect. When I'm in a courtroom, this is hallowed ground. Where I am at right now is the bedrock of what we do in this country. We're a country different than all other places, in that we require, when someone is accused of a crime, that it be brought before a jury to make a decision, and that the proof of it is not just, I think you did it, might do it, more likely you did it, but you must have solid, no question evidence beyond a reasonable doubt. It requires that to be evidence. There's not been evidence at all. The state still doesn't know how it happened, where it happened, why it happened, who it happened, or even with what was used for it to happen. Do not make the mistake of allowing your emotions to be involved in this case so that you say, we must have a verdict some way because a tragedy occurred and I need a verdict. Do not, as I said in the opening of this case, in your rush to seek justice, do so on the cross of innocent blood of Trinity Poague, who has not had a thing to do with the injury that occurred to that child. It was a tragedy that occurred for reasons that I will not stand here and tell you I know the reason. But the interesting thing is, they don't know either. Oh, they know it's a death, they know it's blunt force, but for all the reasons I've told you before, they do not know. I trust you when you go back to the jury room that you will consider the law. You will consider the evidence, or in this case, the lack thereof, and you will return the only just, the only righteous verdict that Trinity Poague is not guilty.
Thank you, Mr. Chairman.